Welcome to For the Record with Greenwood Law.
Welcome to For the Record with Greenwood Law and attorney Dylan W. Greenwood, founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal courts, known for his high-level professionalism, representation, and hands-on approach to every case. I'm Lisa Mosby, your host, and today we're talking about firearms charges in North Carolina cases where a single detail can determine whether someone is facing a state-level allegation or a serious federal offense. Welcome back, Dylan.
Thanks for having me. I'm happy to be here.
You know, we never start with the easy stuff where you're concerned. With firearm laws in North Carolina, they can be confusing for people who don't interact with the legal system. When a new case comes in, what are the first factors that you look at to understand the level of exposure the person might be facing?
Well, I have to say, you couldn't be more correct about that. There's a lot of misinterpretations, misinformation about just what the law is surrounding firearms in North Carolina, about things you can and cannot do. And it is an ever-changing aspect of our statutes and jurisprudence. The first thing that we tend to look at in these types of cases is, this is truly an area of the law. The old adage that possession is 9/10 of the law. Well, possession is 9/10 of anything firearm related, because most of the cases are centered around possession of firearm by felon issues, concealment issues. And so those tend to hinge on how someone may or may not have possessed something. And oftentimes that comes down to a very small detail.
And many charges stem from situations where someone didn't even realize their conduct was unlawful. What kinds of everyday scenarios most commonly lead to firearm-related arrests in North Carolina?
So I've seen that play out in a few different ways. Most often, the ways I've seen that play out center around concealment issues. So without a valid concealed carry permit in the state of North Carolina, it is unlawful for you to carry a firearm in a concealed fashion, or really any weapon in that regard. There's some limitations there, or some things that are allowable, but in general, you can't conceal a weapon without that permit. The way that might come up is let's say that someone borrows your car and you forgot that you left your gun in the glove compartment or in the center console, and you get stopped for a ticket, and officer goes, "Hey, are any firearms in the car?" You go, "No, there's no firearms in the car." "Well, do you mind if I search?" "Oh yeah, whatever." I mean, people do that all the time. You shouldn't do that. Under no circumstances should you ever consent, but people do all the time because they think that by consenting with a figure of authority, it's going to go better for them in the long run. And then all of a sudden, they didn't know about something, and boom, an officer finds a firearm or something else that they didn't really know was there. Now, in those scenarios, the prosecution, the state of North Carolina, has to show that you knowingly possessed that firearm. So that's a big point of emphasis, and that's a big detail. And your ability to say, "Listen, I just got this car. This is my car. It's registered to someone else." It can matter a great deal. I've also seen that play out in other ways, like with possession of firearm by felon, scenarios where somebody entered a house, a store, they worked somewhere where they didn't know that a firearm was held somewhere. And then all of a sudden they were there when something happened. A firearm was located nearby or around in that area, and the attempt was made to try to charge that individual with possession of firearm by felon because of their proximity to that firearm. So it can have a lot of far-reaching implications and impact, especially if you are a designated felon or you don't have a valid concealed carry permit.
And when does a gun case stay in state court? And what types of circumstances tend to bring in federal agencies or federal prosecutors?
Sure. Federal prosecution usually comes in when certain factors are present in a firearm case. For instance, if automatic weapons are a part of the issue, like you possess automatic weapons without proper licensure or certain entities set up that allow for the possession of automatic weapons, not by an individual, but maybe by something like a gun trust, then that there's a better possibility that something like that will go federal. Another version of that would be like a sawed-off shotgun. So like you took the barrel and you shortened it below the requisite number of inches, and all of a sudden it's illegal. That has a higher chance of going federal. Anything where there's an altered serial number also has a better chance of going federal. If you have been prosecuted by the feds before, and then all of a sudden you're found in possession of a firearm, almost every single time, that's going to go federal. And especially if you've had a prior possession of a firearm by a convicted felon in federal court before, that will also be a certain designation within federal court. The other way this can happen, and I've seen this happen a number of different ways, is if you get enough higher level convictions in state court, and they go and they go and they go and they go, and basically the state or the federal government's long-term view of you is that you might mess up again at some point. You might end up with a number of different felonies that add up over the years where you've gotten out maybe on probation or short stints in prison, and then all of a sudden you get caught with a firearm. And that might go federal because all of a sudden you're eligible for something called armed career criminal, where you're talking about large mandatory minimums. You're going to be taken out of society for, potentially 2 decades. I mean, like it's, so there's a long-term aspect to certain people as they've been targeted. But when you look at it from a state perspective, if it's just a normal case, a normal possession of firearm by felon case, a normal concealment case, that's going to go more towards state court than any type of federal prosecution.
And you mentioned a little bit about a case where you might be found close proximity to a gun. Without naming details, is there a case from your career that illustrates how one fact, maybe a location, a prior record, or how a firearm was stored, dramatically changed how the law applied?
Yes. So when I was saying that earlier, that case was running through my head. And I was hoping you would ask me this because I thought about that situation, and this guy was working at a convenience store. He was a convicted felon. He'd worked hard to get this job, and it was obvious he'd worked hard to get this job, and he was very dutiful, great worker, whole deal. The guy before him, the shift before him, was doing the overnight shift and had brought in his own personal firearm and had put it like at the bottom of the glass case at the convenience store for his protection overnight, and had left it because he needed to get a ride from somebody or something like that. And he didn't want to take this gun with him in the shared ride that he was getting from work back to where he lived. Reasonable, fine, I get it. So he left it at work, but he left it at work in a very open place. So then my client is working, not really paying attention to the fact that this is down there in the bottom of the case. And North Carolina ALE, which is alcohol law enforcement, comes in. And they routinely go to convenience stores, vape shops, that sort of thing. Anywhere that sells alcohol, nicotine products, vapes, that sort of thing. And they were just kind of doing a bit of an inspection, and they see this. And he sees them look down. And he looks down and he sees what it is. And he's kind of like, oh no, this is not good. And so then he all of a sudden picked up a charge for this. We pulled in so much case law. We got the clock in, clock out records from the convenience store. We got the surveillance camera footage from the convenience store, where we showed that, it was really this other person's gun. Our guy had never really done much of anything with it, manipulated it, that sort of thing. And that case was eventually able to be figured out and went away, and it did not really harm our client. But at first, they were coming after hot and heavy because North Carolina ALE is kind of known for that. And I mean, that they have every right to, given like what they, what's in their wheelhouse. But, we had to explain, this whole situation about what was really going on with this firearm and how our client didn't really have the ability to even possess this. Like, it was there, but it was never in his possession. He didn't manipulate it. It wasn't his gun. It wasn't something he felt like he could have or take or own or anything like that. It wasn't like that.
Dylan, you said possession multiple times, and possession by a felon is one of the most serious firearm charges. How do North Carolina and federal law differ in the way that they handle these cases?
Mostly in the penalties. The elements are pretty much the same. I mean, are you a convicted felon? Did you possess a firearm? And possession comes down to whether you actually possessed it. So actual possession, like on your person, like that's how you think of actual possession. Constructive possession would be like, let's say a gun was on the table in my office and it was mine. Sure, I wasn't holding it, but I constructively possess it because it's in my space. It's my gun. It's in my possession. It's mine to manipulate and handle and hold. That's at its core, that's the basic difference. There are some nuances, but that's the basic difference. When it comes to state versus federal, you still have those same elements, but man, the penalties go crazy. In state court, it's a Class G felony to possess a firearm by a convicted felon. And a Class G felony, even when you have a certain record level, you keep going up, record level points, based off what you've done in the past, you can get to a level 3, a level 4 record level and still potentially get probation, for a Class G felony. There have been times where I've had a client of mine that's had a record before, and obviously you're going to have a record if you're a convicted felon, but had a little bit more of a record where I was able to get probation for possession of firearm by a felon because of so many other factors surrounding the case. Federal court, mandatory minimum 5 years. Like it is very strict. No opportunity for probation. You're going to prison, and it's very, very serious. So it's a huge difference in the penalty.
And then search and seizure issues come up constantly in gun cases, especially during traffic stops. What aspects of the stop are most important when you're evaluating? And you did lean to this earlier. Don't say yes when you're asked for somebody to search the car. But what's so important while you're evaluating whether the firearm was legally discovered or not?
So one of the things, because more often than not, this comes up in traffic stops, more often than not, because you have a reduced expectation of privacy in a car or a truck or SUV, some sort of vehicle. You have a reduced expectation of privacy versus a home. And more often than not, possession of firearm by felon cases occur in automobiles. I'm not saying, I've seen plenty occur in, related to a house, residence, or apartment, but more often than not, it's a lot of automobiles. So in those scenarios, you're trying to ascertain, was for like a concealment issue, was the gun in a place where somebody could actually reach it? Because that's a necessary part of the analysis. If the gun's in your trunk, or even if you got an SUV that has all the way back where you could, you'd have to crawl over all your seats and stuff, but you could get back there. If you're in your driver's seat at the time of the stop and it's all the way in the back, in the trunk or the cargo part of your car, whatever it may be, and you can't get to it, you might get charged with possession or with concealed carry offense, but it's not valid because you've got to be able to reach it in some way. So we always ask where the firearm was in the car or where it was found in the car. If it is in a case that's locked, that's another way where that case might go away because you can't get to it. You're allowed to keep a gun in a firearms case locked. In fact, I would say more often than not, officers would appreciate that during a traffic stop because that ensures their safety. It's still technically concealed, but you don't have the ability to access it, right? So that's one thing. Another thing is there some sort of plain view aspect? Can they see the butt end of a firearm? So this is something that usually gets litigated because if you can see like the butt of the firearm or a piece of it, is it really concealed? For in a possession of firearm by felon case, yeah, it's there. Okay, plain view. We see that a gun's there. Oh, you're a convicted felon. That's pretty much done deal. But in a concealment case, is that truly concealed? And I had a case one time where a gun was on the floorboard of the car, of the passenger side of the car. So technically speaking, when somebody was walking up to the car, they didn't know that the firearm was there. But as soon as the officer got to the side of the car, shined a flashlight down, looked directly down at my client, goes and moves the firearm just a little bit this way, and you can see plain as day a gun on the floorboard. And it was charged for a concealed carry offense. And I was like, there is no way in the world that is concealed. Like that, it is on the floorboard out in the open. And I had an officer tried to tell me, well, it was concealed because at the time we walked up to the car, we couldn't see it. And I said, okay. I said, imagine that I had a gun on my hip right now. I was like, I'm allowed to open carry in North Carolina, albeit not in a courthouse, but other places. Let's say I was open carrying. And I said, let's say I just turned to the side. You can't see the gun on the side of my hip. I said, am I all of a sudden concealing this gun just because you can't see through my body to see this gun that's on my hip? And he was like, well, it was definitely concealed in this. It ultimately got resolved. It got thrown out because it wasn't supported by case law. It wasn't supported by anything. I mean, that really did. It hinged on where that gun was and the fact that the officer could see it. And it was on video, plain as day.
And that's those nuances that you're talking about.
Absolutely.
Sometimes, a firearm is found alongside drugs, cash, or maybe other items that can escalate the situation. How does the presence of those additional contraband influence how prosecutors view a case?
Oh, that's a great question. So, depending upon the type and weight of drugs and the types and number of firearms involved, that can be an easy way for a case to go federal. That kind of combination, when I hear that at certain levels, my mind, that's where it immediately goes. And even though somebody may not initially be charged in federal court, I'm still thinking that way, that it ultimately might go that way, because that's the type of case that has traditionally been zeroed in on. It can lead to enhanced drug charges. So instead of it just being a possession offense, it might be possession with intent to sell and deliver, because there's a thought that, why do you keep guns and drugs in the same place where you're using a gun to protect product? And why would you need to protect product? And it's because you're doing something transaction related with it. That's the analysis there from usually the prosecution side of it. But it's not always that way. Sometimes it can have a very innocent explanation, whatever that might be in that particular scenario. And every single one of these is very fact dependent. The way I see it play out, just if you're getting to the nuts and bolts pragmatic aspect of it, it will make a prosecutor hone in on the case a little bit more. It might make them dig in their heels a little bit more about a potential resolution. There's always concern about the safety of law enforcement. If a gun was around and, there's always that concern that could lead to something or could have led to something, especially if somebody was not forthcoming about the gun being around and they could access it. So that's something that plays into the analysis for a prosecutor. And then just in general, the fact of having guns and drugs in the same place, like I said, it can make a prosecutor reticent to give you the best deal potentially in a case. And there's some more hurdles you have to overcome from the defense perspective on it.
And I think that's where we'll leave it today. So thank you so much for some clarity and creating guidelines, helping us to understand these guidelines a little bit better. Folks, that's it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about attorney Dylan Greenwood and his work with Greenwood Law, visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal cases. Thanks for listening, and don't forget to like, subscribe, and leave a review if you found today's episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.